Good evening and welcome to this Tuesday, April 15th, 2014 meeting of the Raymore Planning and Zoning Commission. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And we'll call roll. Please remember to make sure your microphone is lighted green and speak into it for the record. Commissioner Anderson.
Present.
Commissioner Burke.
Present.
Commissioner Crane.
Present.
Commissioner Pfizer.
Present.
Commissioner Grodzki.
Present.
Commissioner Hanner.
Present.
Commissioner Meiske.
Present.
Mayor Kirkhoff.
Present.
And Commissioner Faulkner is present. We do have a quorum and the full commission. No personal appearances scheduled this evening. One item under the consent agenda, which is acceptance of minutes of our April 1st, 2014 meeting, and unless any of the commissioners have any concerns about those, I would entertain a motion either to accept the consent agenda or accept the minutes of that meeting as presented.
Mr. Chair,
Yes, Commissioner Anderson.
move that we approve the consent agenda as presented, please.
I second.
Motion by Commissioner Anderson, second by Commissioner Meiske to accept the consent agenda as presented. All those in favor, raise a hand, please. 9 in favor, none opposed, no abstentions. And that takes us to our case under old business this evening. Case 14003, Unified Development Code 19th Amendment regarding stream buffers. Case will require continuing the public hearing, and Mr. Carteret, if you would, present case 14003 to us, please.
Yes, sir, thank you. The case 14003 this evening, public hearing continued from our February 18th meeting. I do want to go through and review items that are included in the staff report. Since this is a proposed amendment to the text of our Unified Development Code, it does require a public hearing, which was advertised for this evening, and I do need to enter into the record several of the exhibits. Exhibit 1 is the Growth Management Plan. Exhibit 2, our Unified Development Code. Exhibit 3 is a notice of publication in the Journal of the public hearing. Exhibit 4 is the staff report submitted to you this evening. Exhibit 5 are the minutes from the May 20th, 2013 council work session. Exhibit 6 is the minutes and agenda item memorandum from the August 19th council work session. Exhibit 7 is the minutes and agenda item from the October 7th, 2013 work session. Exhibit 8 is the agenda item memorandum dated January 13 of 2014. Exhibit 9 is the adopted stream classification overlay map. It's dated 4/5/2006. This is the overlay map that's contained within our watershed management plan. Exhibit 10 is a letter that was submitted by the South Grand River Watershed Alliance that was submitted at your last meeting back in February. And then Exhibit 11 is the February 18th, 2014 commission minutes, again, when you last had discussion on this case. I did include in the staff report the requirements for the commission to consider when you do amend the text of the Unified Development Code. Trying to briefly go through some of the comments. The watershed management plan that the city of Raymore is under was accepted by the council back in 2006. And that's really the guiding force for the creation of our stream buffer protection provisions. They were first included in the Unified Development Code back in February of 2008. Again, and this was a recommendation out of the watershed management plan. And the stream buffer provisions are just one of the best management practices that is utilized by the city to reduce impacts of development in the watershed area. The discussions on possibly revising our stream buffer protection provisions first occurred back in May of 2013 at a council work session. That's why I included those minutes for your review. Part of that discussion, it was really focused on the city's stormwater discharge permit from Missouri Department of Natural Resources. And council was advised by staff at that time of some of the concerns we've had from annual reports in annual meetings regarding this permit. That it was felt that too much land area was currently exempted from the provisions of our stream buffer ordinance. And at that time, council's direction was simply to advise the council of a development status each time a preliminary plat extension request was going to come back in front of them. They wanted to be aware of what the impacts potentially would be if the stream buffer did apply to a particular subdivision. So we did that beginning in May, and I outlined we've actually had, I believe, 7 requests for extensions where we provided the council that exact information for them to consider when determining if they were going to grant an extension to a preliminary plat. After we did a few of those extension requests, in August, at a council work session, staff provided an update and additional information to the council. Specifically, council at that time wanted to see what land areas are considered exempt. And so we did that through the use of a map, identifying what land areas are exempt because they're currently final platted, what areas are exempt because of a preliminary plat, and what areas were exempt because of a memorandum of understanding. At the conclusion of that particular work session, council directed staff to notify the development community interested parties of a meeting to be able to further discuss the topic. And what we did was notified and advertised individuals of an October 7th work session with council, wherein a council would open up the floor and allow comments from the development community and other interested individuals concerning the stream setback provisions. There's a lot of discussion at that work session. At the end of the work session, council simply decided to take the comments under advisement and didn't provide direction specifically at that meeting, other than we would have additional meetings in the future if the topic of an amendment was to be considered. In January of this year, that's when council actually directed staff to proceed with amendments to the stream buffer provisions. So we provided that notice again to any developers that would be impacted by the ordinance, meaning that if you had an MOU or had a preliminary plat, you were provided notice of the hearing on February 18th. Again, I included the minutes of that discussion. We had, as you recall, a lengthy discussion that evening. And at that time, staff requested time to consider the comments that were made at the public hearing and requested a 30-day extension of the public hearing. And that again was a second 30-day extension was granted in March, which leads us to this evening. So we haven't had any direct discussions publicly regarding the proposal tonight, but we have had discussions. We have made it available to individuals. We've after your March 18th meeting, we sent out notice again to all the parties that were involved with the February public hearing, and again the development community of the hearing this evening, including a draft. At that time, it was draft 2 of the proposal that we were going to present this evening. We did also meet with the Good Otis developers, as well as the estates of the Good Ranch developers. We directly met with those individuals regarding the impacts on their developments. Since the February meeting, staff has done a lot of research, consulted individuals, trying to get input regarding the proposal. We have made modifications since your February meeting, and I did identify those in the staff report, and I want to briefly go through those. Again, they highlight what we consider to be what would be a significant change, if you would, from the February 18th draft. The first, and these aren't in a particular order, but the first proposed section change is where the proposal acknowledges that if a clean water Act, which is a Section 404 permits required by the Army Corps of Engineers, that the city's going to defer to the permit for any stream protection, and the city stream buffer requirements will not apply to any stream segment covered by the permit. So this is a pretty significant item. The Corps has always had jurisdiction. If the Corps has jurisdiction of the stream, they always would have trumped whatever requirement we had. We're simply acknowledging that if in fact a Section 404 permit is issued, that the city is going to abide by whatever that permit indicates is required to occur. So we're simply indicating that if you have the permit, that is what controls that particular stream segment. Another section of the code acknowledges that if a Section 404 permit is not required, then the city stream buffer applies to a stream that's identified on our stream order map with a tributary area greater than 40 acres. So it does take some of the Order 1 streams that would have a tributary area of less than 40 acres out of the mix. If that stream, again, does not have a tributary area greater than 40 acres, then the stream buffer doesn't apply. We're continuing to propose the elimination of the exemption for property that's only covered by a memorandum of understanding. That's consistent with what we did at your February 18th meeting. But we have added an exemption for a property that has a development agreement with it that contains provisions for post-development water quality mitigation and best management practices. We did this in an effort to try to acknowledge the efforts that some of our developers have taken with their proposed developments when their corresponding preliminary plat was first approved. And we've actually gone through this process with the estates of the Good Ranch, where they, through discussions, and the city staff was aware of what improvements were going to be done as part of that subdivision, things that they had actually agreed to do back when that particular subdivision was approved before the stream buffer ordinance was in place. And so we acknowledged the efforts that they did, and what we have done through the development agreement is basically binded the current and any future property owners to specifically do those items that we've identified that need to be done. And it is our belief that by accomplishing those items, that particular development is in compliance with our stream buffer provisions. So it provides to the developer an amount of assurity that they know that even if staff were to change and have a different interpretation, they know exactly what they're required to do. So it's an agreement, just as we do with development agreements for final plats. This is exactly what they have to do. This is what the city has to do and what we will do. And it gives them the assurity to move forward. It takes out that uncertainty that we heard concerns about back in our February public hearing. That was a pretty significant change that we made. Another change, we have clarified that for stream segments that are within the FEMA designated floodplain, that the limits, the floodplain limits of the stream buffer shall not be greater than the floodplain. So if your stream and the buffer is within a floodplain area, it's the outer boundaries of the floodplain. That's the outer boundaries of the stream buffer. Also indicate that when a stream buffer plan is required to be submitted, that a restoration plan and a maintenance plan shall be included. It clarifies that the Director of Public Works has authority to review and approve a stream buffer plan. That's similar to what he has the approval authority of a traffic study plan. So we take it in the same vein as that. And it continues to clarify how the width of a stream buffer is measured. And again, there are a few other provisions in the 19th Amendment that not directly related to stream buffer, but are related to preliminary and final plats. We're clarifying that a final plat application must be approved in order for the expiration date of a preliminary plat to be automatically extended for 2 years. Before, what could have happened is if you had a approval of a preliminary plat, the developer has 1 year to submit a final plat application. But if they submit that application, that gives them an automatic 2-year extension of that preliminary plat, but our code doesn't say they have to do anything with that application. As long as it was a complete application when they submitted it, they can just say, hold on to it, and we're not moving forward. They could do that as simply a means of getting a 2-year extension. All we're saying is that if you file the final plat application, you need to continue to proceed with the review of that application in order to get the 2-year extension. So if that final plat's approved, then you can get, if that final plat is approved, that you can get the 2-year extension to your preliminary plat. We also want to clarify the procedure for requesting to extend an expiration date of a preliminary plat, and it provides some factors for council to consider when reviewing a request for an extension, and then it reinserts a requirement regarding the final plats of single-family residential have to be at least 20 lots. Not directly related to the stream buffer, but related to the preliminary final plat. I do want to note one significant change, again, that's being made here with the stream buffer ordinance is by removing the automatic exemption for MOU, it does make the stream buffer protection apply to what we've calculated as an additional 1,700 acres of land. So we look at the 2 MOUs that are not covered by preliminary plats currently, being the Carroll Master Plan and being the undeveloped areas of the Good Ranch. If those 2 developments do not come in with some type of development agreement, then they do become subject to stream buffer. So it has brought in quite a few acres of land under the requirements of the stream buffer ordinance. Staff has submitted findings of fact regarding, for the Planning Commission to consider regarding the proposed text amendment. And a couple of comments under the staff recommendation. Back when stream buffer provisions were first adopted back in 2008, the city did take a very conservative approach to how we were going to implement the stream buffer, and quite a considerable amount of land was exempted from the provisions of the ordinance. And since that time, each year we've heard concerns from EPA and the Missouri Department of Natural Resources regarding the amount of area of undeveloped land that's not subject to the stream buffer provisions. So we have had pressure put on us to try to bring more land under the requirements of stream buffer. We took an in-depth look at the matter, tried to make considerations of the impacts this would have on a property owner in the development community, as well as the environmental benefits of protecting a greater amount of undeveloped land along the stream corridors. Again, we believe removing the automatic exemption of an MOU is appropriate. The MOU still exists for the purposes it was created, and it may be for the benefit of certainties in land use or density or parkland dedication. Whatever the purpose of the MOU is, we're not changing that. But we don't believe that should be the automatic reason for you to be exempt from the stream buffer. We do believe in the use of the development agreement. We think it is a way for the developer to have that certainty and the city to have that certainty of exactly what could and will occur in the future regarding protection of streams. So we do still have that available within the proposed code for any property owner to take advantage of. Again, as I mentioned, after our February meeting, we had several meetings with interested individuals. We completed a lot of additional research. And the current proposed ordinance that's submitted to you this evening, discussed this evening, has been available for all interested individuals to look at. The staff does recommend that the commission accept the staff proposed findings of fact and forward this case to the council with the recommendation of approval. I do want to note that we're under no timetable to get this to city council. I have not advertised for the city council public hearing because I wanted to make sure that if you're ready to make a recommendation tonight, so be it. If you need additional time, have direction for our staff to do additional research, or just simply want to have time to take in the information we've given and the comments you'll receive from the public, you're certainly welcome to do that and table this to whatever date certain that you would want to table it to. I just want to make sure you're aware that we are under no time constraint to get this moving forward. The exhibits that I mentioned, some of them were included, of course, with the original packet. A few of them are included in the packet this evening. And Mr. Krass and I are available to answer any questions. It was the two of us that drafted this, what is now considered the third draft. And again, The change from the second and third draft dealt with specific language regarding that paragraph on development agreement. We simply tweaked the language on regarding the development agreement. But other than that, the ordinance language has been consistent since we sent it out to the to those interested parties, and it's been posted on the website, and I have copies available this evening if anybody needs one.
Thank you.
That concludes my report.
Yeah, thank you, Mr. Carteret, and Commission does appreciate your getting the packet out early to us. Gave us a little more time for review or procrastination, whichever the case might have been. Okay, so as we continue the public hearing, for anybody who has not heard this before, let me ask that once, I don't think we ever closed it, but I'll just say once we reopen or continue the public hearing, you'll have an opportunity to come forward to the podium. If you choose to speak on this case, please start off and give us your name and address for the record. Commission normally asks that you limit your comments to, I'm just going to say a few minutes if that's possible. I think hopefully since we're continuing it, we won't need any terribly long testimony, and if you're speaking in agreement with someone who's already spoken to us this evening, rather than reiterating the position entirely, if you'll simply indicate that you're in agreement with so-and-so who has spoken already and help us keep the proceedings moving. Having said that, let me, I guess, continue the public hearing on case 14003, UDC 19th Amendment stream setbacks. And whoever would like to come forward to the podium and speak to us this evening, please feel free.
Just to be clear, Chairman, you're opening the previously continued hearing, is that correct?
Yeah, that's probably a better way of stating it. Opening the previously continued public hearing on case 14003.
Good evening. My name is Doris Sherrick. I live at 10807 East 205th Street at Peculiar, and I am with the South Grand River Watershed Alliance, and I would like to make a few comments this evening.
Of course.
As stated in the 2006 Watershed Management Plan, the City of Raymore hired B&IM architect firm and Tetra Tech EMI Incorporated to develop a watershed management plan because they wanted to help preserve the existing hydrologic conditions, enhance riparian habitat, and protect water quality for future generations of Raymore citizens. So the plan was written specifically for the City of Raymore with the intent of developing a natural resources framework aimed toward the better management of water resources. If you have not read this very comprehensive and readable plan, I highly recommend that you do so. You can find it on the city's website. In the development of the watershed management plan, a wide range of methods was employed to collect and analyze data of the many components of the watershed: the soils, the hydrology, the topography, and the land cover. Differing engineering techniques enabled them to accurately assess stream order and to map them. The report notes that Raymore is at the top of 5 different watersheds, and I have a map sort of give you an idea. This area is the South Grand River watershed. The 5 different watersheds are composed in this Big Creek, and I believe Lumpkin, and that one to the north.
If you wouldn't mind, Ms. Sherrick, would you just point specifically to where we are in Raymore? That's Raymore. Thank you very much.
So water from Raymore washes off into these different watersheds. One of them ends up in Longview Lake, Lake Winnebago, I believe. And ultimately, all of this part goes down to Truman Lake. This area encompasses 2,000 square miles, and I believe the one to the north is a little over 200 square miles. So it gives you an idea of the size of our the South Grand River watershed.
Huge. Thank you.
The city of Raymore used the plan as a guide in developing an admirable stream setback ordinance in 2008. However, the ordinance was rendered practically ineffective with inclusion of a provision that all MOUs within the city limits were exempt from complying with the requirements of the ordinance. Those MOUs covered nearly all the developable land in Raymore. In 2013, with increasing pressure to better conform with stormwater BMPs, the city brought forth a proposal to eliminate the 5-year-old grandfathered exemption for MOUs and began taking public comments on a new proposal. Since this process began, apparently the effort has lost the original focus and has turned into an effort to weaken protections to minimum standards. Surely the citizens of Raymore and those downstream deserve better than minimum standards on stormwater management. As you are no doubt aware, because Raymore is at the top of the watersheds, this means there are numerous first-order streams that some consider to be expendable. However, they are in fact where watershed health begins or where watershed degradation begins, depending on the level and type of protections provided for them. You may be interested to know that on March the 25th of this year, the EPA and the Army Corps of Engineers released a proposed rule to clarify protection under the Clean Water Act for streams and wetlands that form the foundation of the nation's water resources. And this is from the news release. The Environmental Protection Agency Administrator stated, "We are clarifying protection for the upstream waters that are absolutely vital to the downstream communities. Clean water is essential to every single American." About 60% of stream miles in the United States only flow seasonally, these are the headwater streams, or after rain events, but have a considerable impact on downstream waters. These are important waterways for which the EPA and the Army Corps of Engineers is clarifying protection. Specifically, the proposed rule clarifies that under the Clean Water Act and based on the science, most seasonal and rain-dependent streams are protected, wetlands near rivers and streams are protected, and some other types of waters as well. The proposed rule is supported by the latest peer-reviewed science. I hope as you consider the stream butter issues before you that you will support a strong buffer ordinance that rises above the minimum requirements and contributes to the quality of life for those who choose to become a part of the community of Raymore and to your neighbors downstream. You might consider this statement from the 2006 Watershed Management Plan. Landowners and developers need to understand that while financial impacts of land development are short-term and affect few people, the environmental impacts of insensitive development are long-term and affect many people. Thank you all.
Mm-hmm. Thank you, Ms. Sharp.
Good evening. I'm Sharon LaRussa, and I live at 1102 Southwind in Raymore.
And I'm one of the founding members of the South Grand River Watershed Alliance and was one of the stakeholders in the group that developed the Raymore Watershed Plan. I attended and spoke at all of the meetings that were involved with the implementation of the Stream Buffer Protection Ordinance in 2008, and have also attended the work sessions and meetings that began last year on this proposed change, except for the March 15th meeting. And it was my understanding that the meeting had been moved to April, so I didn't attend, so I apologize. Otherwise, I would have been here. I'm going to share my comments on the proposed changes, but I also have a recommendation that I'll conclude my comments with. If you have not had the opportunity to read the Watershed Management Plan that Ms. Sherrick spoke of, I think it's a great basic document and it references points specific to Raymore. It has a wonderful glossary of terms and other information you'll find applies to this proposed change. I also have a copy of a publication that was developed under the U.S. Army Corps of Engineers Ecosystem Management and Restoration Research Program entitled Improving Riparian Buffer Strips and Corridors for Water Quality and Wildlife. I have some copies that I brought, and you can make copies if you want. Now I'll give you my comments on the proposed draft. With regard to the terminology, with a tributary greater than 40 acres, I know that this has been added to the ordinance in various places, and I saw a reference of how the area, I never did see a reference to how that area is determined. At least with the city's stream map, you could see what order the stream was and then compare that to the buffer chart. It was plain and easy to read. I also wonder on that definition of tributary area of greater than 40 acres, does that consider only the acreage? Or does it consider the geomorphology of the area? There's clay soils that are less pervious, and then there's sandy loam that absorbs the water. There's hillsides and rock, and that's all in Raymore. And these all have an effect on the water quality issue because they absorb at different rates, and 40 acres, depending on where that location is, can have a big change in how that's done. And I'm not familiar exactly where that was taken from, but I do know that the APWA 5600 has reference to it in section 5605.3. And I have that section back in my area too, if you'd like to see what that does. And it does say, as one of the recommendations in subparagraph 1, preservation of smaller streams is encouraged. And it seems just that Raymore already has a stated stream buffer for the small orders, that there is no need to use that default method of that 40 acres. We already have every stream defined on the city map and already have that in place. Therefore, I feel that the reference to the tributary area greater than 40 acres may need to be reevaluated. In addition, as first and second order streams are the backbone of the stream system and extremely important, especially in Raymore, as it's at the top of the watershed, as you saw with the map. Whatever happens in Raymore affects all the water that flows out of it, north to the Missouri River and south to Truman Lake. And in addition, the change that we've looked at, the proposed change, I did not see any direct reference to address tributaries of less than 40 acres. So what happens to those? It only addresses those with more than 40 acres. With reference to the new proposed 455.040, the above information needs to be reevaluated throughout, and in addition, reference to an exemption to property that has development agreement that contains provisions for post-development water quality mitigation and best management practices does not seem to fit in with stream buffer preservation ordinance. The water quality, the stream buffer does not have anything to do with post-development. It has to do with preserving water quality and allowing infiltration of water and filtering of pollutants before they get into the water. They seem to be two different areas. It would seem that unless the stream mitigation has already been approved by the Corps of Engineers, then it would be difficult to know exactly how the stream would be impacted and premature to grant an exemption to property until the EPA or Corps of Engineers has approved a mitigation plan, especially given an exemption that was based on a preliminary plat. Another change pertains to stream segments within the FEMA-designated floodplain that states that the stream buffer shall not be greater than the floodplain. I think it should say that the stream buffer will be the greater of either the floodplain or the buffer width stated in the stream buffer chart in section 45504C. Because floodplain only handles floodwaters. Stream buffers handle completely different way of dealing with the water quality. One area in the change that states that a developer would be allowed to submit a geomorphic study to justify lesser setback distance than required by the stream setback provision. I think that this should work both ways, and that the change should also state that if the study finds that either a lesser or an additional amount of buffer width is required, that amount will be implemented. Regarding the information following the buffer width chart in section 455.04C1C, I think it should state that when the Director of Public Works approves a change to the buffer width required on one side of the stream, when it is impractical to provide equidistance widths, the buffer on the other side increases so that the total width is equal to the total shown on the chart. In conclusion, as one of the stakeholders that worked on the watershed management plan, I can vouch for the quality and the amount of work and information that went into that document. The planning group was made up of BNIM architects and Tetra Tech EMI, along with the stakeholders group. The stakeholders group was made of developers, interested parties, which included members of the South Grand River Watershed Alliance, and private citizens. The document presents why and what Raymore needs to do to protect its streams and why it's so important that the requirements and specifications that were developed were specific to Raymore. The stream map was developed specifically for Raymore and presented a detailed and accurate view of the area. I also in attendance spoke at all the meetings in 2008 regarding the stream buffer ordinance that was presented and subsequently adopted, as I am interested in what happens to the streams and waters in Raymore and the entire watershed. Regarding the current draft, I understand that the previous draft change was originally proposed in order to bring the exempted MOU land under the requirement of the current stream buffer ordinance, and to give the city the ability to look into ways to more closely evaluate preliminary plat extension request, and was not intended to be a significant change to the actual stream buffer wording. In fact, it was pointed out at the February planning and zoning meeting as one of the public comments that many of the comments expressed earlier in the meeting seemed to pertain directly to the stream buffer wording and not the subject at hand, which was to discuss the MOUs and the preliminary plat extensions. However, this proposed change now appears to change the wording in all areas. It is my understanding that these new changes were drafted with input from the developers and Mr. Flick. I feel that the proposed draft now contains enough significant changes that input from interested parties and private citizens should have be incorporated also. Therefore, that I ask that you do not approve this proposed change to this ordinance tonight, but table it to allow time for separate meetings of all parties to have an input into this change before it gets voted on. Thank you.
Thank you, Ms. Larissa.
Good evening. My name is Bob LaRussa, and I live at 1102 Southwind Drive. I've been a resident of Raymore for almost 40 years. In addition, I was one of the founding members of the South Grand River Watershed Alliance, of which I'm still an active member. The introduction for the agenda for the August 19th, 2013 work session stated the following. At the City Council work session of May 20th, 2013, City staff provided information regarding the city's stormwater MS4 general permit and the measures it requires the city to take to improve the quality of stormwater runoff. During discussion, it was noted that the EPA would prefer that areas of undeveloped land in the city limits that was the subject of previous agreements between developers and the city have been grandfathered in, meaning they do not have to meet all the requirements of the city's stream buffer ordinance. Staff was asked each time a preliminary plat is brought forward for renewal to advise the council of the development status vis-a-vis the stream buffer ordinance. Mayor Kirchhoff asked staff to provide additional information about what areas are considered grandfathered from the city's current requirements for stream buffer protection. In its memo, staff provides this information and a recommendation for moving forward should council wish to consider changes. No mention of the changes to the stream buffer ordinance, just elimination of the exemptions for MOUs. At the August 19th, 2013 work session, stream buffer ordinance exempted areas, it was stated that the city's stream buffer protection regulations are outlined in section 455.040 of the Raymore City Code, which was adopted in February of 2008. Section 455.040A1A provides an exclusion for land or to development which is on land covered by an approved unexpired memorandum of understanding, where such approval was given prior to the effective date of this section. It was further stated that in order to remove the exemption, it will be necessary to amend the city code. A brief history was given as to why the exemptions were given and a brief description of all the exempted properties. It was then stated that if the city council is interested in modifying the exemptions now in place in the city code, staff would suggest inviting the development community in order to receive input prior to making any changes. This would ensure that the development community has the ability to express its concerns directly to the governing body prior to any proposed action. Again, no mention of changing the stream buffer ordinance, just the elimination of the exemption for MOUs. At the October 7th, 2013 work session, the staff made the comment that, quote, the city adopted a stream buffer ordinance, not a stream preservation ordinance. It is possible and probable that some of the Order 1 or Order 2 streams may be eliminated as part of the development process if the property owner can document that the U.S. Army Corps of Engineers does not have jurisdiction over the stream. If no jurisdiction exists, the stream may be eliminated as part of the development process, end quote. This was, however, not a recommendation, simply a comment. The staff did make the following recommendation, and I quote, it is staff's recommendation that the City Council propose an amendment to the Unified Development Code to eliminate the exemption for undeveloped subdivisions and for subdivisions with an MOU, end quote. Again, no mention of changes to the stream buffer ordinance, just the elimination of the exemption for MOUs. February 18th, 2014, Planning and Zoning Meeting. This is the first time that any changes to the stream buffer ordinance are presented by the city staff. Up until this time, each and every work session only addressed the elimination of the exemption for MOUs from the stream buffer ordinance. Now, in addition to proposing the elimination of the MOU exemptions, the city also made the proposal to clarify the applicability of the stream buffer provisions. The proposed revisions indicates that a property owner could remove an Order 1 or Order 2 stream if the U.S. Army Corps of Engineers does not have jurisdiction over the stream and the City Engineering Department approves a plan depicting measures that will be implemented to replace the lost value of the stream buffer. At this point, I became a little confused. All along, we have been discussing MOU exemption removal, and now a proposal for a significant modification to the stream buffer ordinance. It was particularly confusing in light of the fact that it was because of the EPA had concerns about the amount of land that was being excluded from the stream buffer ordinance in the form of MOUs that started this whole process. And now we were proposing that developments could simply remove Order 1 or Order 2 streams. On March 20th, I received an email from Mr. Jim Cataract. It contained 2 attachments. The first attachment was the revised stream buffer protection provisions that the city staff intended to submit to the Planning and Zoning Commission at the April 15th meeting. The second attachment was a memo which contained a brief summary of significant changes made since the February 18th meeting. The memo states in part, quote, Since the February 18th, 2014 Planning and Zoning Commission meeting, staff has worked on incorporating comments provided at the public hearing into a new draft of proposed revisions to Section 455.040 Stream Buffer Protection of the Unified Development Code. Subsequent to the meeting, staff met with representatives of the development community and with Mr. David Flick to further define the new draft of proposed revisions." End quote. I was present and spoke at the public hearing on February 18th, 2014. At that time, I pointed out that in spite of all the twists and turns the discussion had taken, this process started out with only one question, and that was and is, should the exemption from the Raymore Unified Development Code, Section 455.040, stream buffer protection, be removed from the properties under a memorandum of understanding? The stream buffer ordinance was drafted after extensive research conducted by BNIM Architects and Tetra Tech EMI, with input from city staff, the developers, and Raymore citizens. The result of their collaboration is the Watershed Management Plan, and from that came the stream buffer protection. I would respectfully request that any decision on the proposed changes to the Unified Development Code, Section 455.040, stream buffer protection, be tabled to allow more discussion and to solicit more input. The current stream buffer protection was a collaborative effort with input from several sources. If we are going to change it, I would request that we provide the same level of effort. It is a very important part of the UDC and can have a great deal of impact on both the residents of Raymore as well as our neighbors downstream. Thank you for your time.
Thank you, Mr. LaRussa.
My name is Larry O'Donnell. I'm Executive Director of the Little Blue River Watershed Coalition. Little Blue River Watershed has its headwaters in Raymore, basically 58 highways, a dividing line going north. Little Blue empties into the Missouri River. Heard a lot of comments so far about this ordinance. I got to agree with the original intent was to remove the grandfathered in MOU exemption. It's gotten into all kinds of other stuff without a whole lot of comment. One of the things, there's several things that bother me. One is the seem to be the weakening of the protections of the headwater streams, and in particular this acquiescence to any segment of stream that has a 404 permit. It's kind of nebulous what this means when they're talking about whether or not there's mitigation required under a 404 permit. 404 permits are under the Corps of Engineers, and they deal solely with fill of waters of the United States. They do not deal with riparian buffers. They require mitigation for fill of waters of the United States. Any permit that's been granted has a mitigation requirement. They don't require stream buffers. They're under their 2008 rule of hierarchy of mitigation. The Corps of Engineers, after years of granting different ways of mitigation for streams, came out with a hierarchy. Their first priority for mitigation is for a permittee to pay into a stream mitigation bank. Not to do it on site, but to pay a regulated stream mitigation bank that is already set up for stream preservation. Secondly, if that's not possible, which in this area it is, their next priority would be to pay an in lieu of fee, which would then go to stream preservation, quite possibly into the state stream stewardship fund. Lastly, they will allow what they call permittee responsible mitigation plan. This is what you see when you see an application for a 404 permit and the permittee has come up with a mitigation plan that they propose. Just because they put that in their application does in no way mean that that is what the Corps of Engineers is gonna end up recommending, and is actually the last step, the last thing that the Corps of Engineers would recommend. So to say that a 404 segment of the stream would be exempt because the Corps may or may not require a buffer, it doesn't hold. I mean, it's like saying that I don't have to obey the posted speed limits in the city of Raymore because the state of Missouri permits me to drive. The two things are not related. You cannot put the onus on the Corps of Engineers when they don't regulate riparian corridors. The other thing about this stream buffer ordinance, it's been called said that it's not a stream protection ordinance and it's not a stream preservation ordinance, and I have to agree. It's a public safety ordinance. We're not doing this to see because we want to take this person's land away or we want to save the fish. We're talking about flood control. We're talking about development. If you have no stream buffer, then they can build right up to the edge. There's nothing to stop them from doing that. The ordinance is what does that. The ordinance is what protects the people of Raymore from future development that can end up costing them thousands and millions of dollars. Because we're talking about, where does the water go when it rains? Where do the floodwaters, where are they gonna go? If you fill in the headwaters and the ability of the land to absorb that water, it's gonna run off. Where is it gonna run off? It's gonna run off downstream. So you filled in this much of this room, it's gonna make the runoff from here go that much faster and that much harder to the next section of stream and negatively impact that section of stream. It's gonna start eroding, you're gonna be putting in too much. So what you're doing is you're taking away your sponge, you're taking away nature's ability to absorb the rainwater, right? So we're not only increasing the amount of rainwater that's coming off, decreasing the amount of infiltration, but then we're gonna try to confine where that stream is gonna go. Well, all you have to do is look at the Missouri River in 2011 and know that we don't have any control over the weather and over the rain. What we do have control over is allowing those streams to perform their natural function. And so, take the thing about the Core 404 permitting out there, preserve the headwaters. The rest of the part about taking out the grandfathered MOUs that's good. I got to congratulate staff on their work with the development community and getting this thing up to snuff. I know it's been put off and given the Good Ranch and the Creekmore just got their another phase permitted. These are all things we want to work with the community. We want to work with the development community. But we don't want to see the development community benefit at the expense of the citizens of Raymore. Thank you.
Thank you, Mr. O'Donnell.
Good evening. My name is
Hi.
David Flick. I live at 17040, what's the name of my city? Highland Avenue, Belton, Missouri, 64012. Had a golden moment there for just a minute. I appeared before you a couple months ago providing my opinion on recommendations for your stream buffer ordinance. I again am here on my own accord. I am a registered agent with the U.S. Army Corps of Engineers representing applicants for compliance with Section 404 and 401 of the Clean Water Act. My comments tonight are meant to be education, clarification on what different orders of stream protection mean, what permits mean from different entities. And you've learned before that there's two orders of protection for jurisdictional waters, streams and wetlands. That is the U.S. Army Corps of Engineers and the U.S. Environmental Protection Agency under Section 404 of the Clean Water Act. They administer nationally a permit program that allows citizens and landowners and developers to seek authorization for them to impact jurisdictional waters. As clearly articulated prior to me, they do regulate the placement of fill and dredge in jurisdictional waters, anything that would result in the loss of waters. The Clean Water Act was first enacted by Congress back in 1972 as a means to prevent industrial polluters from continuing to dump waste into our rivers. Back during the time our rivers were on fire, President Nixon promptly vetoed the Clean Water Act, and Congress overruled him, and it became law. Since then, through a period of legislative actions and rulemaking, it's expanded to what we have now, which pretty much any place that water goes, things are regulated. Yes, there is new rulemaking that's proposed right now, and no, that rulemaking really doesn't change anything that was currently jurisdictional today. Basically, if it's a seasonal stream or a roadside ditch that flows water, it is regulated at some part. Now, a couple of things I will point out to you is that your stream preservation ordinance does not authorize anyone to impact a first or second order stream. It does none of the same. That authority to impact a jurisdictional water solely belongs to Congress and the Army Corps of Engineers. Congress authorizes every 6 years conditional rights to the citizens of this country. The citizens can go out with no permit and impact jurisdictional waters that have considered a minimal impact. That is known as our nationwide permit program. And nationwide permits are not issued to individuals, they're issued to the nation for anyone to use. All that's required for a landowner or developer is to seek pre-construction notice. Write a letter to the Corps, call them, tell them what you're doing. So if you have a stream in your front yard and you own a house and you want to put a pipe in it, as long as that is not a special type of water and your impacts are below 300 feet, you don't need a permit. You're authorized to do it. It is a conditional right handed down by Congress to the citizens, and it's known as a nationwide program. Now, people get confused because we talk about 404 permits, and large developments that impact more than minimal waters are issued individual permits. These are permits where it's more than just a little bit of stream that's proposed. I met with city staff and brought an example in of a residential development. The average residential development today avoids 80% of all jurisdictional waters, even with no stream buffer ordinance in place. Avoids 80% because under federal law, those streams are protected. And the Army Corps has a practicability measure. It has a very complex evaluation process by which they look at and determine, is a taking of a stream by a developer or by a citizen or by a city government or a parks department or our MoDOT or our Missouri Department of Natural Resources or the federal government themselves, is that taking justifiable? Is it practicable? And as a part of that alternatives analysis, the Army Corps looks at all associated factors: economics, public safety, environmental protections, endangered species, cultural resources, all are looked at. And the only permits that are issued today, the only permits are the ones that the Army Corps, in consultation with state and other federal agency, deems is practicable and represents a public benefit, not a private benefit. The Army Corps knows in areas such as Raymore and Belton and Harrisonville, it's important that we maintain economical lot prices. An average residential lot here will sell from $22,000 to $35,000 a year. In areas where we can achieve less development density, those prices have to increase. And so the Army Corps understands that economical housing is important. They understand that government buildings such as this, which, by the way, if you had your stream buffer ordinance in place, this building would not be sitting here, because you would have been required to miss 2 ephemeral channels that sat on this lot and everything. This building would have had to have been somewhere else. The Army Corps looks at the benefit of density versus the detriment of urban sprawl. The less density that you allow development to have, the more open lands that are taken up in order to provide more living units, more shopping centers, et cetera. All these facts are part of the practicability analysis under federal rules and everything. And it's really amazing today, because there's a lot of people who believe that once you get a 404 permit, that allows you to wipe out everything that's on your property. It does not. And in fact, 404 permits highly scrutinize the filling of any channel. So my recommendation to you as a part of your revision of your stream buffer ordinance is to identify and recognize the authority of the Clean Water Act. It's very important. We have communities around the metro who have set stream buffers to mandatory protect streams. The federal government will step in, and under their authority, if they tell the developer that that stream must be taken out, then under Office of Council rules, their law takes precedence. And you saw a recent project here in the Kansas City area where that was clarified. Because many of these ephemerals that are buffered by local ordinance are impaired waters. And the real purpose of a stream buffer ordinance is to protect the aquatic resources of our receiving waters. I think all of us here will agree it's important that we not only protect streams, but we encourage people to improve the quality of those streams, improve the riparian corridors. So I salute city staff. I salute the changes in this new stream, what's recommended stream buffer ordinance, because it not only establishes default buffers for all streams that the Army Corps doesn't regulate for impact. It sets a default, but it also puts into place maintenance procedures, things to do to take care of the stream. Because buffering the stream by itself does nothing. Buffering a denuded conservation resource does nothing but basically allow further impairment of it. And much of what we're buffering today are resources that have been manipulated by mankind. They've been allowed to grow up in way too many trees, too many of the wrong species of trees, and it allows us to not only protect these important waters, many of which are headwaters, but allows us to then continue monitoring and maintaining these stream buffers, for their enjoyment. So the Army Corps regulates this under Section 404, and the state of Missouri also has authority under Section 401 of the Clean Water Act. And under Section 401, the state is responsible for administering water quality regulations. Now, you might be interested to know that the state has not to date completed the legislative action through what's called the JCAR process, the Joint Committee of Administrative Rules, that basically mandates on a statewide basis that we have these protective stream ordinances. And there's a very good legal reason why, because it's different in Missouri than Kansas. Missouri is a state regulated under riparian water law. Kansas is a state regulated under Western water law. In the state of Missouri, every citizen has a constitutional right for the enjoyment of the state's waters. The right of capture, the right of release is indoctrinated in the Constitution, which is why you don't see regulatory agencies taking on this. Anything done to separate a citizen from his right to enjoy those waters and everything, by either not allowing them to own it or not allowing them the benefit of capturing and releasing and enjoying it for domestic, would obviously come with a constitutional challenge. So as a state, we pretty much tiptoe around the issue. And on the 401 program, which every time you get a 404 permit, you get a 401 permit at the same time. The state only conditions water quality in the 401 program to be associated with best management practices, such as rain gardens, bioswales, etc. Not once has the 401 program, who is the legal authority under the Clean Water Act for water quality protection, mandated a stream buffer setback as a part of a permit conditional requirement. Now, the statement was made tonight and is very true. The Army Corps does not have, as a part of its program, mandatory stream buffers. If you're using an existing stream and making improvements to it on the site as mitigation, there are mandatory buffers associated with that. But in general, the program only regulates what's happening in the stream. So your ordinance as proposed would provide that sort of protection. The Army Corps says the stream can be graded or filled in or a pipe put in it. There is no riparian corridor left. As prepared now for your evaluation, only streams not authorized for impact are subject to the stream buffer protection for what's there. There's also been some discussion, about the size of the buffers and what's right. And this is a combination of science and engineering. We have subject matter experts out there, licensed entities, engineers who are trained in geomorphology. You have biologists who know how to assess the system. And I believe it's a very workable solution for those to work and seek the approval of Mr. Crass, in this matter, in order to understand all aspects of what's important. And the thing I point out to you is that a lot of talk tonight has been about this is about developers. Is it really? I think it's about all of us. You want soccer fields and parks for the future? Okay. It's every development that's out there. It's shopping centers, it's schools, it's hospitals. We're all subject to the same set of rules by the Army Corps of Engineers. Kind of in closing, share with you that this is a very complex matter. There's been some discussion tonight about, well, let's regulate all the streams, and I don't understand why we're regulating the 40 acres. I met with staff and prepared for them stream buffer ordinances from all metropolitan Kansas City communities and identified for them what and how they regulate the stream buffers. 80% of our communities regulate on a watershed basis for 40 acres. That is a part of the stream buffer template that was first introduced to all of our communities. Raymore was one of the few who, against our recommendations, regulated by stream order. In fact, only 2 communities that I know regulate by stream order, Independence and Raymore. And what happens in Independence if the Army Corps authorizes the impacts of one of those lower order streams? Then those impacts go in place because that's part of the practicability analysis that goes into it. So what 40 acres lets a city do is then regulate those, not necessarily higher waters, but maybe order 2 and 3 waters. The only thing that the 40-acre rule takes out is those areas that, are they a stream or are they not? And the Army Corps will determine whether it's jurisdictional or not. Well, no matter what you call it, if it's jurisdictional, it's jurisdictional. It's something that has bed and bank. So the 40-acre rule is meant to be a practicable rule for everyone to follow. If not, it's meant to be a small minor stream. It doesn't mean it's automatically should be impacted. It just means that, that those occur commonly, and that evaluation of whether it impacted or not is really up to the 404 permit in their rule. So I'll close my comments tonight by saying, it's a very complex issue. I salute my colleagues, including Larry and his years and years of work for everything. I recognize the work of Mr. Dan Drake, who is here in the crowd with us tonight too, of the Midwest Mitigation Oversight Association. We are all citizens, so I believe want the same thing and maybe have a slightly different opinion on how it's done. But in the end, we're here to share with you a perspective so that you as the governing body can decide what's best for you and for this community. So I thank you for your time.
Thank you, Mr. Flick.
Good evening. My name is Dan Drake. I live at 21301 Shelby Lane in Belton. About a 25-year resident of Cass County and president of the Midwest Mitigation Oversight Association. A little bit about our organization. We're a volunteer organization that holds conservation easements throughout the states of Missouri and Kansas. Roughly 150 easements at this time. Feel free to go to our website if you'd like to learn a little bit more at midwestmoa.com. Tonight, following the impassioned folks that are here with the watershed and the brilliant minds that have spoken here tonight, you know, I have very little to say other than with our background and what our volunteer organization does and goes out and evaluates these easements and see how they are handled, maintained throughout the life of the easement. Buffers are wonderful things. Stream corridors are wonderful things. Above and beyond that, properly maintained buffers and stream corridors is what really needs to take place throughout. The non-native invasive species that often infiltrate the buffer areas is not good for the streams. It's not good for the watershed. Properly maintained native species, great thing, you know. What you guys are trying to do and what you're thinking about doing and making your changes tonight or in the future and how they're regulated, it's a difficult matter for all of you. You're gonna upset parties on one side or the other, no matter what. I can tell you it is my opinion that the changes that are proposed are a good thing for the community, a good thing for the residents, a good thing for the developers throughout. We would be happy to consult with you at any level that we can, offer whatever services that we might add. I know you've been through this and hashed it out 100 times. You've got a number of experts sitting behind me that have been doing this for more time than I have, and our group has. But an improperly maintained non-native buffer is not the way to go. A properly maintained buffer, stream corridor, and so forth is the proper step to protect the waters downstream, protect the waters that leave the sites. And I guess that pretty much wraps up what I have to say. Thank you all. Have a good evening.
Thank you, Mr. Drake.
Give Good, 195th Street and 71 Highway, Raymore. I wanted to clarify, it was brought up that in the beginning it was just, one of the ideas was just to change the memorandum of understanding. Others, but ours also, Good Rancher or Good Otis Development, which is true, but when that was decided to exempt that, we didn't need to think about stream water, the ordinance before that. When the city decided that they would possibly exempt that, then we did have to consider that. But we had to consider another thing, and I stated this earlier. That's a contract, and one side of a contract can't unilaterally exempt itself. It has to be by mutual consent. What's before you today is probably not supported by me personally 100%. That doesn't make any difference. It seems to be a workable thing and something that we can live with in the future with whoever the city staff is that we're going to be working with. And that was our goal. I would still like, under the memorandum, to define that more, and I hope to do that. We haven't quite worked out that language. At some point soon, that kind of language would be in front of the city. That's about all I have to say. Thank you all.
Thank you, Mr. Good. Is there anyone else that wishes to speak to the commission this evening on case 14003, UDC 19th Amendment, stream setbacks? And seeing no one, I'll close the public hearing and open the floor for discussion by the commissioners.
Mr. Chairman.
Commissioner Crane.
Jim, I've read through this 3 times. I've looked on the internet. This poor old accountant's having a hard time getting his arms around it. The questions that I have 2 questions basically. The first question is, are we trying to put stricter provisions than what federal law and the Corps of Engineers administers? And if not, why do we not just rely on the Corps' provisions to govern this? And then the second question, and I think that may have got kind of answered for me tonight a little bit to where I have a better understanding of it. And the second one is, under the current MOUs, have we worked out an arrangement with them? I worry that the city may have made promises that they now want to pull back on. And that's why they're wanting to do away with the MOUs. And I worry that people have put a lot of money into this and would suffer irreparable harm if we laid some rules down that we wouldn't be able to work with, that we wouldn't allow them to mitigate a problem because we say it's got to be this way. You know, you can't put a pipe in, you can't do this, you can't do that. So, I mean, if you can answer those 2 questions, I'll be happy.
I'll start with the second question first, if that's okay, and then we'll see who's going to try to answer the first question. The MOUs that we currently have in place, the 3 that we're talking about, that we have been talking about that are covered currently through the stream buffer exemption, are Creekmore, the Carroll Master Plan, and the Good Ranch. All 3 MOUs done at different times. Of course, the Good Ranch done back in 1994, so it by far is the oldest one. Creekmore was done in 2003 era, and then the Carroll Master Plan after that, I believe, in 2005, 2006 timeframe. Each one was done for very specific reasons for the property that it covered. And certainly the city respects, acknowledges the agreements that were made through those MOUs. It was a memorandum of understanding, an understanding. It doesn't rise to the level of a development agreement, but it's still an understanding of what will occur, what the developer is going to do and what the city is going to do. And we believe we are not in any way impacting what that MOU does for each specific property. We're not changing any of the terms of the MOU. What we are saying is that unless the MOU specifically had language in it that exempted it from any future code changes, those developments as they move forward in time are complying with the different code changes that we make and have been complying. Now the terms of the MOU we're holding to, so if we change what's allowed density-wise in a particular zoning district, we still have to hold true to the density that was approved in the MOU. Yes, we changed the code, but the agreement said this. But the agreement, if the agreement didn't address the stream setbacks or stream buffers in any way, then what we're saying is that MOU that deals with land use or transportation matters doesn't exempt them from a new requirement that's been placed on everybody. And that's why we're trying to pull just the fact that you have an MOU out of the list of exemptions. Now what we're trying to do in its place is, if there is considerations that have been made with a particular phase or development, then let's honor that specific agreement that's been in place or understanding that's been in place about stream protection. And that's what we did in the example of the estates, and that's what we're offering to any landowner. So we believe that we're on solid ground by proposing the exemption of the MOU. We don't believe that we're taking away rights of the agreement and doing something that we are not able to do. I mean, that obviously is a question that has been posed to the city attorney's office many times through this process, to make sure if we pull out the pure exemption for MOU, are we on solid ground for the city? And we certainly could allow Mr. Zert to expand on that. To go to the first question, are we trying to put stricter conditions in place than what the Corps currently has in place, and why not just rely on the Corps provisions? I'm going to allow Mr. Krass to address that.
It actually complements each other. It's actually, they're complementary. They're not, one is more excessive than the other. The Army Corps of Engineers, as was stated, deals with the stream, impacts to the stream, relocation of the stream, things that are dealt with, that developers need to get permits for are culverts, culvert crossings, road crossings, those type of things. In this case, if they want to alter the stream, remove the stream, that is under the Corps of Engineers jurisdiction. What we are dealing with is, as part of our stormwater discharge permit, our water quality issues and developing riparian corridors and protecting the riparian corridors and establishing or reestablishing riparian corridors. That's what the purpose of the stream buffer ordinance is. And there's been a lot of discussion about the number of changes that have occurred. A lot of them, especially on the first page, section 1 in the red, section 2 in the red, is simply a clarification. That language under 455-0404-A 1 and 2 is really a clarification and a refinement of what's on page 2 of the ordinance, which is struck through under letter F. This is the original language from the original ordinance that was adopted. If a development obtains a Federal Clean Water Act individual 404 permit allowing a stream to be relocated or otherwise altered, et cetera, et cetera. That was the original language adopted in 2008. What the first page does is just clarify that a little bit better and expand on what the jurisdiction is, and those type of things. It simply clarifies that. So I hope that, Mr. Crane, did that answer your question?
I'll think about it a minute.
Okay.
Thank you, Mr. Cataract and Mr. Krass. So in the meantime, do other commissioners have questions? Commissioner Hanner, please.
First off, I wasn't here for the original meeting on this, but I'm reading through the May 23rd City Council work session. As part of the discussion on the city stormwater discharge permit from the Missouri Department of Natural Resources, the council was advised by the city staff of concerns from the EPA that too much land area within the city of Raymore was exempt. I've been with the government for a very long time. I've never heard of the government stepping in and saying we have a concern unless there was a violation there. So are we violating any kind of federal regulation? Because my understanding is they don't have a buffer requirement under the federal government. It's not the buffer requirement, it's what happens when it hits the basin. Okay, is that correct? So how do we, I'm trying to get some background information. How does the EPA come into here?
Through our MS4 permit, our NPDES MS4 stormwater discharge permit, we are required to have measures in place that reduce the impacts to stormwater quality for anything new development. Under their under the definition of new development in our permit, it is anything that disturbs more than 1 acre. It does not take into account any previous approvals or, whether a plat is in place, whether a preliminary plat is in place. From a practical standpoint, and I'll, defer to Mr. Zur a little bit on this, there are certain vested rights that people have as part of the stream, as part of a preliminary plat approval, a final plat approval, that do need to be protected when you start drafting these type of ordinances. The concerns that were expressed, again, maximum extent practicable is the language that's used, and new development or redevelopment that disturbs more than 1 acre. When you start looking at model ordinances that we borrow from when we draft these ordinances, they all have some sort of language for an exemption clause regarding preliminary plats, final plats. They don't have, an MOU is not something that rises to the same level of refinement and investment on the part of the developer as an MOU does, or that an MOU does not rise to the same level as a preliminary plat or a final plat. So yes, that is why, and that is how we get input, is through our stormwater discharge permit. Mr. Zur, do you have?
Yeah, I'm happy to provide additional input on that. Our firm has had the opportunity to look at this as far back as early December of last year. In fact, I think that Mr. Willarth was involved in a number of items, but as of December of last year, we provided a legal opinion to the city with regard to the stream setback ordinance and provisions for what the potential impact would be in these types of changes. And the analysis that was provided by Mr. Willarth in his correspondence to the city manager at that time was a breakdown of a takings analysis, and a takings analysis under federal law being unable to take property for public good without just compensation to a private citizens for those. Under the analysis that was provided, obviously a final plat held the highest degree of certainty for a developer. They had invested time, effort, money, infrastructure, and so on into the construction of their development, and at that point has a highest degree of concern with regard to a taking and a potential liability for the city in that regard. Beneath that would be the preliminary plats, and beneath that development plans or don't let me throw development plans in there, MOUs would be at the lower level of that, based on the question of what all goes into the developer with regard to those MOUs. The analysis that Mr. Willarth provided was also along the lines of what steps have been taken and reliance has been made by the original developer based upon those MOUs, what infrastructure has gone in, what other development aspects have been provided based upon that MOU. The final result of it was it can be viewed as a case-by-case basis with regard to potential liability, but the MOU level is the lowest level of potential liability that you run into with that.
One other question. You mentioned that as a result of somewhere in here, and I can't find it again, I apologize, but you mentioned something about 1,700 acres identified as being, can you clarify what that meant? And then I'll ask my question.
Yeah, what that number represents is the amount of undeveloped land that is currently covered by only an MOU. So currently, if you take the undeveloped land of the Good Ranch that doesn't have a preliminary or final plat, and the undeveloped land of the Carroll Master Plan that doesn't have a preliminary plat approved, all that land added together, undeveloped land added together, that would now be subject to the stream buffer protection provisions if we eliminate the exemption for MOU, is what it represents.
So what you're saying is by calculating out the buffer that we're proposing, or that's in the thing, that adds up to 1,700 acres?
No.
Or there's 1,700 acres that touch it?
1,700 acres just of undeveloped land
That have these level of...
that right now are exempt from meeting any of the requirements of stream buffer. If we adopt what we're proposing this evening, we are adding 1,700 acres of land within the city that are now subject to the requirements.
Has there been any look to see how much of that land would actually come off the table for development then? How much of that 1,700 acres?
We have overlaid various requirements of our code on that undeveloped land. We've overlaid the floodplain and what amount of land that takes out. We've overlaid the stream setbacks as they apply to the Order 1 through Order 6 streams. So yes, we have done that. We have seen that for the subdivisions.
Right, and Mr. Cataret, correct me if I'm wrong, but Commissioner Hanner, if you find the one-page color map in the packet, I think the 1,700 acres is the purple.
It is.
Shown
I see
exempt-
that, and I'm looking at that, but
exempt by MOU.
it doesn't mean that that whole 1,700 acres is undevelopable.
Oh, no.
What it means
It
is
simply means
there's
it's
a
currently
wider,
undeveloped.
there's a wider swath for each stream or creek or whatever you want to call them that runs through there. Is that correct?
Well, the way I understand this is currently, I'll get my agencies mixed up here. I apologize, but currently I think EPA objected to the fact that we had exempted so much undeveloped land from ordinances going forward, and this movement of 1,700 acres from the old status of exempt per MOU to now being part of new city code, that shift, I think, is an attempt to address EPA's concern. Mr. Krass or Cataret, feel free to correct me.
No, that is correct. And one of the overlays we did do, in specifically for the Good Ranch, is take a look. There is a certain amount of green space within their MRU that was going to be set aside. So we, as Jim said, we overlaid the floodplains and the stream buffers and the green space to be dedicated, and it all correlates pretty well.
And I remember at our February meeting, not to try to go back through all of that, but it was either Mr. Good or Mr. Otis, I believe it was Mr. Otis, pulled up one of the early maps of the Good Ranch development and pointed that out to us, that even at that early stage, there was a significant amount of green space in the original plan. And I think that's also reflected in the February 18th minutes somewhat. Commissioner Burke.
Mr. Chairman, permission to ask Mr. Krass a couple questions.
Oh, feel free.
All right. It's pretty much the same question, but with 4 different groups. Wanted to know, in the development of what the proposal tonight, did city staff request input from the EPA and guidance with this? Just
What we will do is every year, as part of our MS4 permit, we have to do an annual update, and so we will submit this as part of our annual update in June to the DNR. Our permit is actually issued by the Missouri Department of Natural Resources. So we will submit this change to them as part of our annual report. Subject to
so that was okay. So that was one of the 4 groups. I was going to ask EPA, U.S. Army Corps of Engineers, the Missouri Department of Natural Resources, and this one's just kind of maybe not applicable. The Missouri Conservation Department, just on opinions based on, is this new proposal trying to maybe give a good faith showing trying to meet the federal guidelines? That's the way I interpreted it, and I felt like we've had different testimony trying to give us more information, and I wondered what those experts were saying. So those were
yes. Well, no,
all,
we have not.
all considered.
We have not submitted
Because it's not final.
It's not final. And
All right.
as I said, it gets a little complicated. The DNR is actually the authority. The EPA has ceded authority under the Clean Water Act for the NPDES and MS4 permits to the Missouri Department of Natural Resources. So that really is the permitting authority that we would submit this to as, does it meet the requirements of our discharge permit?
And so it is the city staff's belief that this is in conjunction with the different requirements that we
Yes.
need to meet. All right, thank you.
Yep, Commissioner Hanner.
Okay. I'm gonna ask for him because he's a little shy. I'm gonna ask this for Mr. Good. Have you taken a look at, without the MOU and the new buffer requirements, how much developable land are you talking about losing?
And by the way, Mr. Good, I won't insist that you come forward, but if we'd like to hear your comments, I would appreciate it if you could come forward to the microphone.
You're asking if this is approved tonight, the way it's stated, how that affects the plan in total?
How much of the developable land, I don't know how much of the 17 acres fall in Good Ranch that is under this MOU. One, pardon my lack of how to call these things, one stream, creek that runs through there that falls into this code with its buffer of 100 feet on, 50 feet on either side, running through there. If you were required to follow that, how much land are you talking about being taken away from being able to be developed? Is it a big impact?
The two main streams were addressed in the early plan under the MOU. And they're wide enough that a lot of them are wider than the floodplain further down. So they're not affected. That was addressed in the plan in the beginning. Our concern was the densities. And if we took the plan, if you just read it like it was written and dropped it on our tract of ground, in some instances, it would take up 50% of the ground, developable ground, if it was defined. And our problem was, and still is, we're fine today working with who we're working with. We don't know who we're going to be working with 10 years from now. Back in '94, someone from the city asked when we would be done, and Jim Otis said 15 years. Well, that's right at 20 years. So we're not quite done yet. And it damn sure looks like we're not going to get done for maybe another 20 years unless things pick up some. So that's a big issue. I told you our history, and I don't know how many city administrators, mayors, zoning board directors, city engineers that we worked with in the first 12 years. It seemed like everybody was changing every 2 or 3 years. So about the time you had a rapport with somebody, they were off someplace else. Well, that's a big issue. And if you've gone through that, you realize how big an issue it is, because you think you're going someplace and then you're not there, so you basically start again. And what I wanted was a definition that we were comfortable with in the future, that it didn't matter who was, we knew what kind of decisions were being made. And the regulatory bodies mentioned in this, we're going to have to deal with anyway. We have to deal with them right now. So that hasn't changed. I don't know if that answers your question, but
I think you went a long ways toward answering that. That's absolutely. Thank you, sir.
Thank you, Mr. Good.
Mr. Chairman.
Yes, Commissioner Crane.
And Jim, and I think that covered really both sides of my questions from before. I worry about people that come in and spend millions of dollars on an intent that they had and an intent that they thought the city had. And all of a sudden we get 5 years down the road and you're gone, and somebody else comes in, and the political football gets thrown around, and there's no set rules for this other than the federal rules. And that's why I asked, are we going way beyond there so that these people are at political whim rather, or have we tried to set something up that says you must follow the rules at the time you committed to do this? You know, nobody likes playing with something that's out there that they never know what's going to happen.
Mr. Carteret, feel free.
If I just expand a little bit on my previous answer, we certainly understand that. We certainly have spent some time with Mr. Good, with Mr. Otis, looking at the MOU, looking at the master plan that was done back in 1994. This plan has been followed. You know, since that time, it has been followed. It's a very good plan that's in place. And we acknowledge that. What we're trying to do with the amendment that we're proposing is, yes, we're talking about taking away that blanket exemption of the MOU. What we have put in its place is something that is more definitive, something that is a true development agreement, something that is laid down specifically by ordinance that outlines exactly what is going to be done regarding the streams in that development. And the process was fairly simple for the first one, the Estates of the Good Ranch. We already have that in place. And that stands alone. Even if we decide not to make any of these amendments, we still have that development agreement in place for that subdivision. For the Good Ranch, it is a little bit more complex. They did an outstanding job, as was reflected when we did these overlays of floodplain and stream buffer onto their master plan of, as Mr. Good indicated, they have the two major streams that run through the property that they have protected with common area when you look at that master plan. And it very, very closely matches the boundaries of the floodplain and matches the boundaries of a stream buffer. So what we're trying to do then is figure out, well, what can be done in the future, and we still have impacts on the stream. So with this agreement, what we're looking for this agreement to say is what kind of commitments can be made, what can be done now, or what can be stated now that will be done in the future regarding improvements that can be made to the stream to mitigate the impacts of all this development on those streams. Yes, they have the corridor for the stream, and we have nice open space. There's still things we need to do to the stream itself. And that's what we're trying to identify now, because we understand the concern of, you know, staff changes, elected bodies, individuals change. We need to have that in writing, in place for Mr. Good, Mr. Otis, and any other purchasers of land, you know, that may come along in that development or any other development. So we're trying to, with this ordinance, move in that area of getting, you know, going from an MOU to an actual agreement, because we feel that has much higher standing both for the developer and for the city. But we're hoping, you know, that does get accomplished soon, so we can have that in place. And I know we're working towards it. I know they're working towards it. So.
Okay.
Mr. Chairman, I'd like to expand on that a little.
Of course, Mr. Krass.
One of the challenges as we're working with the Good Ranch is a lot of the excuse me, a lot of the regulations that we were dealing with did not come about until 2002.
Right.
And so what we are, as Jim explained, when we overlay things, the buffer widths match up pretty good to the green space that the Good Ranch is proposing to dedicate. The floodplains match up pretty good. The element that is missing is outlined under section B of the ordinance, the buffer and stream setback requirements, in particular, the plan requirements, the maintenance of the buffer, the replanting and restoration of the buffer. I'm not sure how your item is numbered, but it is 455040B.
Okay, and I might ask for clarification, we've actually got two separate copies of the draft. Do you have the one that's green and red on the front and says third draft?
Yes.
Okay, so we should be on the same
So, and
page.
so the areas we're talking about is under, is B1, 4 and 5, and
Right,
in
right.
those on
Top of page 3 on
on the
our
top of page
copies.
3, yes,
Sure,
sir.
gotcha.
And so
Thank you.
that's the elements that we need to get incorporated
Right.
into the development agreement that is referenced in this, in the revised ordinance.
Right. Okay, so I would say, from my own point of view, I'm very impressed with the third draft. I think it reflects not only a lot of effort on the part of staff and the various stakeholders that you've met with since our February meeting, but I think also to me, it makes sense, and I think it incorporates a lot of, I think comment was made earlier by one of the speakers that we probably won't please everyone, certainly not satisfy everyone on everything, but I think this third draft represents not only a big improvement over the February draft, but I think also that it's something I feel like it's time to go ahead and move this to City Council. We actually, if you think about the history of this case, it started with City Council and got put on Planning and Zoning Commission. Personally, I think we've given it sufficient hearing that I'm ready to act on it this evening and hopefully send it back to City Council. I do have a couple of very minor questions I'd like to clear up before we do that. And Mr. Zur, if you'll look at one extremely tiny little subtlety. This is in the so-called third draft. Bottom of page 4, it's 455.040 C5A, and it's talking about the following structures, practices, and activities are permitted in the stream buffer, et cetera, and it goes on to define them, and it says in A, activities for the purpose of building one of the following, and then it enumerates a bunch of different possible items underneath it, and I wondered if that might be better if it said for the purpose of building any of the following, or perhaps, the way it reads, I can imply that it only allows one and only one of those, and I don't believe that's the intent.
Well, if you're looking further down at the or,
Right.
those are provisions that we have not addressed changing with regard to this proposed amendment at this
I
point.
understand.
Those are
So-
currently already in.
So at the end of 4, there's a red or?
Yes, that's correct.
True.
Yeah, which I would have viewed as simply filling in at the end of the day a prior, I don't know, Jim, was that a typographical that was being addressed with that or? Because the language up above, which is activities for the purpose of building one of the following, has not changed.
I'm not really worried about the fact that it hasn't changed. However, the purpose of this case is presumably to improve the current code, Mr. Krass?
Mr. Chairman, that's not the first issue like that we found. That's why there's a lot of the little reds. It is appropriate that would be changed to any. The intent is that there is a list. It's not only one of those.
I know. I understood the intent. I just felt like, unless Mr. Zer tells me otherwise, I felt like it would communicate the intent more clearly with the word any instead of the word one. So
Any one of the following, or
Yeah,
are you going to do just any of the following?
I think it's actually clearer saying any of the following.
And removing
I'd
the one?
substitute the word any for the word one.
Yeah, I'm okay
But
with
that's-
removing the word one and having just any of them.
Okay.
The or in there will simply indicate that it's going to be one of those at the end of the day. As long as you don't do the and or
No, I
in
know.
that section, you're good.
I was trying to make it better, not subject to more interpretations, but that was something that I picked up. The other question, Mr. Crass or Mr. Cataret, so if a first or second order stream is determined not to be under jurisdiction of Corps of Engineers, hopefully I've said that right. These multi-agencies can be very confusing. But if it's not under their control, if it reverts back or comes back to city control, that I believe is still based on the city stream order map. Am I correct? Okay, so my specific question was exactly who controls that city stream order map, who makes updates to it, who approves it, and who addresses any disagreements that someone would have if they came to the city, for instance, and said, I think you're wrong, I don't think that's a first order stream. Mr. Crass?
Just as with anything, as with the traffic plan or anything, the developer can submit information by qualified people that show that when they've done more detailed topography on their site, that those streams don't exist, and we would review it just as we review any other. In fact, we've had that occur with some developments.
I'm sure we have.
And so that is the process.
So this isn't something that would come back to Planning and Zoning Commission, it
No.
would be dealt with by city engineering?
Yes.
Okay, and I'm fine with that, I just wanted to make sure I was clear. Commissioner Burke?
I just had a comment, little bit of my background. I've not wanted to say this before, but my bachelor's degree is in biology education. I spent several years studying environmental science and biology with the intent to possibly work in conservation and things like that. I also have certified to teach earth science and have spent over a decade looking at some of these issues and teaching about water quality in the classroom. I'm not an expert by any means, but I feel like that I am a little qualified to read over this and feel to have an opinion, and I feel that the intent is to do the right thing here with regards to the environment and to the business and development communities, and I think there's some good work here.
Commissioner Grodzki?
Yes, I missed the first meeting, so I apologize for that. And maybe this was done earlier on, but we do have several residents in Raymore that are interested in providing more input on this. It was stated while they were speaking. Are we kind of past that point, or is that still an option for us to allow them to give their input?
If I can speak, I'm sure there are others who could answer the question as well, but I would note several things. The case was publicly advertised for February, continued to March, was re-advertised at Commission's request, was re-advertised for this evening. So I do feel like we've given this a decent amount of notice to the public. In addition, of course, this case, Planning and Zoning Commission is a recommending body. It's our job to hear testimony, make a recommendation to City Council, but unless we table the case indefinitely, it will eventually go to City Council and have another advertised public hearing and certainly we'll have another opportunity for public input, public comment. Mr. Zur, I think I'd like for you to agree or modify what I've just said.
The commission obviously has the opportunity to decide what they want to do this evening. I'd probably defer you back to Mr. Catterat's comments that he made at the outset of this. You have had the opportunity to consider this at a public hearing. You've had the opportunity to continue that public hearing for additional input from staff and members of the community as well as the development community. I'm not going to tell you what you do and do not have to do this evening. What you can do is forward along if you believe you've received the testimony that's sufficient for making a decision and make a recommendation to the City Council. The City Council would have further input and the opportunity for additional hearing further on down the road. This will become a recurring subject for the mayor to consider the next couple of weeks.
If I may, I'm a slow study, so it's a good thing that I get to hear it multiple times, so.
Well, I think I might have said that, a glutton for punishment, but I guess I won't contradict you. Mr. Zur, as always, thank you. Appreciate your legal opinion and your recommendation that the case this evening is to be decided by this commission. I actually would not this evening, and well, simply because I would note I've closed the public hearing on this, and unless I'm corrected, I
Perhaps it would behoove the commission to have the Corps of Engineers appear before them and explain what they do and don't control.
okay.
Things here tonight.
I'll say thank you, but I don't wish to reopen or continue the public hearing unless the commission feels otherwise.
Thank you, Commissioner.
Mr. Chair,
Commissioner Anderson.
I'd like to make a motion.
Before we go further,
Pardon?
I'm sorry, you're anticipating a motion here. There was a comment about making a change to the activities for the purpose of building any of the following under 5A.
Right. Yes. Noted C5A, and just if you choose to include it, if you choose to include it, it would be there's in the red and green.
Okay, the change that you made.
Yeah, if you choose to include that in a motion. I'm not sure what your motion is going to be yet.
Okay, go ahead and make a motion.
You have the floor,
I
Commissioner
have the floor.
Anderson.
Thank you very much. I move to accept the staff proposed finding of fact in Ford Case 14003, 19th Amendment to the UDC, to the City Council with a recommendation of approval inclusive of the change on Section 5A, specifically changing one to any.
Second.
Okay, so we have a motion on the floor to accept staff proposed findings of fact on case 14003, UDC 19th Amendment, stream setbacks, and forward to City Council with a recommendation of approval, including a change to Section 455040, paragraph C5A, to change the word one to any. Motion by Commissioner Anderson, second by Commissioner Burke. I probably said that already. Is there any further discussion on this case? All those in favor, raise a hand, please. 5, 6, 7, 8. We have 8 in favor. Any opposed? Commissioner Grodzki opposed. No. Abstentions, and as always, Commissioner Grodzki, we'd be happy if you'd like to voice your position for the record. Feel free.
I guess I was just in favor of letting it sounded like maybe there were some miscommunications on the residents getting their input in, and I feel like they should have had their say, but it sounds like they'll get that chance at the next level, so.
That was a good short break, and I'm sure everybody is anxious to wrap this up and get home sometime this evening. So, Mr. Zur, I think we're actually ready for the City Council report, if you would, please.
I'm happy to provide the City Council report this evening. As always, I would invite Jim and Mr. Krass, along with the mayor, to chime in on anything that I might get wrong based upon the fact that I was not present and I'm getting everything from Mr. Willard. So, first and foremost, I think it's important to note that a former member of this commission, Mr. Holman, has now taken his place in the council and is adding his input to the process there. So nice to see individuals where we have the opportunity to work with them at this level and have them move up that ladder into the bigger world of the full council. I'm going to provide you a report from the Monday, April 14th, 2014 City Council meeting. First and foremost, they had a second reading of a final plat for the High Point at Creekmore. Second plat, this was a 24-lot single-family subdivision proposed along Creekmore Pond Lane in the Creekmore subdivision. Planning and Zoning Commission considered it and approved it by a 7-0 vote on March 18th, 2014. Received its initial approval from, first reading approval at City Council on 3/24 of 2014. The next item that was identified is a master development agreement for the estates at the Good Ranch. This was a development plan or a development agreement that's been prepared and set forth regarding the amenities for the developer to provide as part of the subdivision, post-development water quality mitigation, and best management practice. The important factor of this as it plays in with this evening, specifically that it now meets the new stream setback ordinance requirements. We now have a development plan with regard to the estates of the Good Ranch in place, at least from your second reading perspective. So that was a proactive step that developer took in order to address the stream setback questions. Next item I've got for you is a first reading for new business. The first item that I have on here, we spoke with Mark Klinkenberg, representing the developer, for a rezoning of Foxwood Plaza Lot 1. There was a public hearing. It was approved by a vote of 8-0. And I'm sorry, I don't know if I mentioned the vote on that last one for the master development agreement. It was a vote of 7-0 with one abstaining. The rezoning for the Foxwood Plaza Lot 1 was approved by a vote of 8-0. This was a rezoning from the R3A multifamily residential district to a PUD, planned unit development district. You'll recall this is for a mysterious or yet unnamed sit-down, high-quality restaurant in the city of Raymore, as yet unnamed. Right?
Potential development.
Nationally known.
Nationally, thank you. Appreciate the input on the keywords there. Nationally known sit-down restaurant. The final item Mr. Willarth wanted me to bring to you was also the final plat, Foxwood Plaza Lot 1, that you saw in conjunction with the rezoning the last go-around. Again, a nationally known sit-down restaurant proposed for that location. It was approved by a vote of 8-0. Those are all the items that Mr. Willarth identified as issues that would be of concern or interest to this board, and I'm happy to answer any additional questions you might have.
Any questions for Mr. Zur? Yeah. Okay. Mr. Ketterer, let's move on to the staff report and planning pipeline, please.
Yes, sir. Thank you. I do want to note that the Planning Commission will have a meeting on May 6th, our regular meeting. We do have a public hearing scheduled that evening. It will be the annual review and report for our growth management plan. We have finalized that document. We'll post that document on the city's website, which we have done. And that'll be the opportunity for staff to bring up to date the work that's been done on the GMP over the past year and discuss any possible amendments that need to be done to that document. And we currently do not have any items for the May 20th meeting, so we'll see if any applications are filed for that particular commission meeting. And then based upon the recommendation this evening, we will be advertising the 19th Amendment to the UDC, the stream buffer discussion for the May 12th City Council meeting. So that'll be first reading for City Council, May 12th. It will be a public hearing. And the only other item I want to make note of is between now and our May 6th meeting is the American Planning Association Conference. Commissioner Crane and I will both be attending that. And it is interesting, I mentioned to Mr. Crane earlier this evening, but the program has been expanded. And it truly is 5 full days of options and activities for learning. And it's pretty impressive. I think they estimate 5,500 planners, commissioners, elected officials will be at the conference. It's in Atlanta this year. So looking forward to some good sessions on some topics that are important to the city right now. So I certainly have my schedule filled out and what I plan on trying to learn from. And I gave a printed version of the schedule to Commissioner Crane this evening. Hopefully it'll help and try to plan a little bit ahead on what sessions are of interest. So
Sure.
They do have a specific track for commissioners, which you don't have to stick to, but it is an interesting track to go. So
A little different disciplines there. Do you think you'd be in a position on the May 6th meeting to give us a bit of an update, some feedback from that, or do you think we'll be tied up that whole meeting with the GMP review?
I think that'll be a good meeting. We'll see how it goes. We'll be prepared. I'll be prepared to give you some, information that we gained from the conference that evening.
And Commissioner Crane as well. We don't have to, if there's particular topics of interest that you want to talk about, we don't have to talk about everything May 6th, but I figured sooner is better before we move on down the line and put too much water under the bridge.
And then one other final comment, just as far as scheduling, our required annual review of the UDC comes up in June. So I don't know that we'll have a lot of discussion like we had the last year because we have made several amendments since our annual review last year. But we still need to go through that process and look at the code and have discussion. But that won't be held until June.
Well, I'm optimistic, but I don't want to trivialize the process.
Exactly. Yep. Still a very important, necessary process.
With commission, this is a wonderful attendance this evening. I'm very pleased. As summer comes along, it may be a little bit tougher to get all commissioners here at all meetings because of vacations and things. So, not to borrow trouble, but we'll see. Okay. Anything else, Mr. Catterad?
That's all I have, sir.
I'll open the floor for public comment. Mr. Eanes, I guess you'd be staff rather than public, but you're about all the public that's left this evening, and so seeing none, let me open the floor for commission member comment. Oh wow, I've got a volunteer, Commissioner Anderson.
So I just want to express the thank you as far as the information that was presented tonight. It was very, 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 very complete. So I think I read it 3 or 4 times at home and still needed some clarification. So if I did that much, I appreciate the time and effort that city staff put into it. So I want to extend a thank you to all the work and dedication put forward. So thank you.
Mm-hmm. Commissioner Fizer.
I would just agree with Commissioner Anderson, and everything was really helpful, and that's it.
Yeah, thank you. Commissioner Grodzki.
No comment.
Secretary Crane.
I want to thank staff for the package. Like I said, I went through it 3 times, and my confusion was not anything that they had anything to do with.
I still contend that there is no such thing as a dumb question, and I certainly am delighted that you asked it rather than I, because I would have had to have asked if you hadn't. So appreciate that. Commissioner Meiske.
I won't be here May 20th, just another reminder.
Oh,
Okay.
thank you. Okay, let's see, Vice Chair Burke.
It's my understanding that congratulations is in order for Commissioner Anderson. I believe he was just elected board president at Raymore Peculiar School Board. So congratulations.
Right. And Commissioner Hanner.
Again, thanks to staff. Like I said, I missed, during the meeting, I missed the bulk of this preparatory discussions leading up to tonight. And the report that you guys provided made it easy for me to catch up and understand. I had some fill-in-the-blank questions. I wish the public was still here, because I do appreciate their involvement in their showing. And that's pretty much it. Thanks.
Thank you, Commissioner Hanner, and Mayor Kirkhoff.
I just have a couple of things. I'll begin with the citizens who are here. I really do appreciate the citizens coming out and expressing their concerns and passions for water quality. It's a good thing. It's a good thing. Mr. Flick, I had a chance in our break to thank him for coming out. His experience was I know it was beneficial to me, and I hope that he comes and speaks to the council when this comes before the council on May 12th. Thanks to the staff for their work on this. I just have this suspicion that had this gone before the council for vote in its original form, it may not have passed. I think the work that has been done has created something that is much, much better than what we had when we started. And I think the council, of course, I don't know how the council will vote, but I would think the council would be much more amenable to it. If it hadn't passed before, we would have been exactly where we were. And now that we have something that will pass, we will be in a better place. So, and I thank the chairman and the members of the P&Z here. You do a wonderful job up here, debating and deliberating and asking questions. Some of the questions that are asked, I don't know where you're going with it initially, and then oh my goodness, I hadn't even thought of that, so I do appreciate it. And you do it for the love of doing it, because you're not getting any pay or massive recognition by the citizens of Raymore for the work you do. But for me and from the council, because I know the council takes a look to see the work that you've done, and how when you move something forward to the council, they recognize the amount of work that you've done. So thank you very much. And that's all I got tonight.
Okay. Thanks, Mayor Kirkhoff. I think I will agree with everything that the other commissioners have said, with the exception that I don't know that I'll be gone May 20th yet. But I want to thank city staff, and particularly our fill-in for recording secretary. I don't believe you've ever had to do this before, but I'm sure that you've developed a great appreciation for how long-winded and convoluted some of our discussions can be, and we'll look forward to seeing the minutes. I usually nitpick them to death, by the way, but Nancy probably didn't tell you that. No, I think it's important to note that this effort, we are all residents of Raymore. As a very wise man said several years ago, don't make me move. We're here because we want to be, and we want to preserve, protect, and improve quality of life in Raymore. And we certainly could not do that without the help of city staff, who does the legwork and brings the professional training and education into the mix. So really do appreciate that. And it's nice to have you here this evening, Mr. Krass. Unless there's anything else to say, I would certainly entertain a motion to adjourn.
Mr. Chairman, I move we adjourn.
Second.
Motion by Commissioner Crane, second by Commissioner Meiske to adjourn. All those in favor, raise a hand, please. And finally, it is unanimous. 9 in favor, none opposed, no abstentions.
Next meeting?
Yeah, I was gonna, you guys, phone each
I
other?
looked over in the middle of the meeting and I'm like,
I'm the rural ward, you're from the urban.
oh, okay. Well, I do have boots. I have ropers, or I have,